Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head out to the state of Michigan. Haven't talked about Michigan a whole lot, except I'm not a real big fan of their governor. But what we need to talk about is Michigan's new safe storage laws, because if you follow the flurry of activity running around on the Twittersphere, Exosphere, whatever we're calling it this week, you will see that there is a great deal of confusion and a great deal of misinformation going on out there about what does this law really require? What does a Michigan resident need to do to actually be in compliance with this law? What does this law actually even restrict and or ban? So what we thought we'd do is something really unique. Apparently a lot of people in mainstream media don't bother to do this. We figured, hey, why don't we just read the frickin' law itself and figure out what it says? So what we're going to do today, Michigan, is going to do something we do very often here at Washington Law. We're going to do a little law English translation so that all of us can understand what your rights and obligations is under this law. So today, let's spend a few minutes, let's geek out on the law, and let's talk about what does Michigan's safe storage law really say? Okay, we are talking about Michigan's safe storage laws, and my experience has been that safe storage laws in general are quite often misunderstood, and like many gun laws, are written by complete imbeciles who have no idea what they're talking about and makes little, if any, sense. But such is the way of the Second Amendment in the year 2024. What we're going to be talking about today is engrossed Senate Bill number 79. There was which is also called the Public Safety Act number 17. There's also a little thing called Public Safety Act number 16, which changed the mandatory penalties and statutory maximums for certain offenses, including for violations of this law. We'll link them up both down below so that you can geek out on it. This is Michigan's new safe storage laws that went into effect earlier this month. Now, if you look at a lot of the tweets or X's or, like I say, whatever we're calling it now, you will see that there are a lot of people out there who believe that when you come home, regardless of your living situation, you must unload your firearm, lock it in a container, put a lock on the firearm before you put it in a lock container, take the ammunition, stash it somewhere else in a different lock container, surround both of them with barbed wire, and set a tripwire on both of them. That's literally what some people think. Is that what the law really requires? Well, I thought what we would do is let's just read the law together and we will figure this all out. So, engrossed Senate Bill number 79, now enacted into law in the state of Michigan, reads as follows. An individual who stores or leaves a firearm unattended on premises under the individual's control and who knows or reasonably should know that a minor is or is likely to be present on the premises shall do one or more of the following. Okay, Michigan. So right there, it is only if you have reason to know that you are likely to have children around. Okay, so if you're living in a condominium or a house all by your lonesome and you don't have little kids running around, you don't have little grandkids running around, you don't have your nephews and nieces, candidly, does any portion of this law even apply to you? No, it does not. If you do happen to have children around the home, then this section of the law applies to you. And it says you have to do one of the two following. 1, store the firearm in a locked box or container. Okay, put it in a gun safe or something like that. That's the rules that me and Mrs. Gun Law have when I come home with my everyday carry. It immediately goes into a biometric safe because I got 2 teenage kids running around the house. The other thing you can do is B, keep the firearm unloaded and lock the firearm with a locking device that is properly engaged to render the firearm inoperable by any individual other than the owner or an authorized user. So your choices are put it away in a gun safe or unload it and put a trigger lock on it. Now, again, that only applies if you are likely to have children present. Now, there is some other requirements in this law, so we need to go through those as well. For example, if you are going to take a firearm onto somebody else's property or premises, the law states this. An individual who enters onto the premises of another individual, stores or leaves a firearm unattended on those premises, and who knows or reasonably should know that a minor is or likely to be present on the premises, shall do one or more of the following. Okay, so this section of the law only applies if you're on somebody else's premises and for whatever reason you decide that you need to leave your firearm unattended at somebody else's premise. And then you have to do one or more of the following. A, store the firearm in a locked box or container. B, keep the firearm unloaded and lock the firearm with a locking device that is properly engaged to render the firearm inoperable by any individual other than the owner or an authorized user. And then, if you, for whatever reason, decide that you need to leave your firearm unattended in your automobile, which is probably not the best way of doing things, but sometimes it is necessary. So, for example, sometimes I travel to courthouses. I can't take my firearm into the courthouse. I think I can probably survive the 20-yard walk from the parking lot to the front door, so I will not take the firearm with me. There's a way that I have to store it in Washington that would be consistent with Washington law. Michigan law now requires the following. In the individual's motor vehicle, store the firearm in a locked box or container in that vehicle, or keep the firearm unloaded and lock the firearm with a locking device that is properly engaged to render the firearm inoperable by any individual other than the owner or an authorized user. 2, lock the individual's motor vehicle. Now, you must do both of those, and candidly, when you take a look at all the steps, because you'd have to have a gun safe in your car or a locking device, and you got to unload it, and then you got to lock the car, which you should be doing anyways. I get all that. It really is kind of a big hassle to leave a firearm unattended in a motor vehicle, and if you take a look at where most firearms are stolen from nationwide, yes, they're stolen from vehicles. Now, an individual can only be convicted under this section of the law and subject to misdemeanor penalties of 93 days in jail. I do not understand that number. And a fine of $500 only under the following circumstances. An individual is guilty of a misdemeanor punishable by imprisonment of not more than 93 days or a fine of not more than $500 or both if the individual violates subsection 1 or 2 by failing to store or leave the firearm in the required manner, and as a result of the violation, both of the following occur. So the mere fact that you have left a firearm unattended in what would otherwise be an unlawful manner is not a crime unless all of this following occurs. A minor obtains the firearm. B, the minor does either of the following. 1, possesses or exhibits the firearm in a public place. 2, possesses or exhibits the firearm in the presence of another person in a careless, reckless, or threatening manner. So unless all of those have happened, Michigan, that is the only way that you could be subjected to criminal liability under this portion of the statute. Now, unfortunately, in this statute, if a minor does access a firearm and then other more terrible things happen, the firearm gets discharged, the penalties get worse. The firearm is used to seriously injure somebody, the penalties get even worse. And if, God forbid, the firearm is used to end somebody else's life, yes, the penalties on the original gun owner who failed to store the firearm in a lawful fashion can be quite steep. As you can see right here from the charts, the state of Michigan is not messing around with this. Now, there are several exceptions, including parental consent, and then sometimes, very similar to Washington, even if you properly store a firearm, if someone is hell-bent on actually getting it, if it can prove that it was taken from a lock safe or that a gun lock or something like that was cut off of it, then actually the original owner of the firearm would avoid criminal liability. So, Michigan, I don't know what you've been told, I don't know what you read, and I certainly don't know what mainstream media has told you. But looking at the actual language of the statute itself, the only people who should be concerned with this law are people who know or have reason to know the firearm, which is going to be left unattended on that premise, is a premise in which children are likely to be present. Then and only then does this law kick in, and then the law only kicks in if a child actually accesses the firearm and bad things happen. Listen, once again, it's enrolled Senate Bill number 79, better known as Public Safety Act number 17 of 2023. We will link it up down below so that you can geek out on the language for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.